Hello and welcome to our new series on artificial intelligence. My name is Charles Mallows. I'm a senior associate in the commercial team at Charles Russell Speechlys, and today I will be delving into the intersection of AI and contract law. As artificial intelligence becomes an essential part of business operations, the process of contracting for AI tools and AI-enabled services has become the subject of greater stakeholder focus. While many contracts will be recognizable as typical arrangements for software and SaaS, there are unique challenges and risks that businesses need to consider. Today, I'll walk you through some of the key issues and how specialist legal advice can help you protect your interests. Firstly, it is crucial that the use case for the product being procured is understood. What business problems are you aiming to solve? Are you looking for predictive analytics, process automation, natural language processing, or something else? The intended use case will shape not only the technical requirements, but also the contractual terms you need to consider. A solution designed for sensitive data or mission-critical operations will require more stringent security provisions and compliance measures. This may also impact the method of delivery from SaaS to on-premises, as hosting data on supplier systems may not be appropriate. What ancillary services will be required to implement the product within your environment? Does new hardware, including more powerful GPUs, need to be purchased? And who is responsible for integrating the product with that hardware and your pre-existing software? Once the use case is clearly defined and understood by key stakeholders within your business, you can consider the terms of the contract. Often suppliers will insist you contract on their standard terms of business, and while this may be a sensible starting point for one-to-many type solutions, you'll need to carefully analyse whether your business is protected from some of the key contractual risks. Make sure your contract addresses the entire life cycle of the AI system, from development and implementation to ongoing maintenance, training and support. Setting clear project goals, milestones and deliverables will help keep everyone in the supply chain accountable. Your contract should specify who owns the data used and generated by the AI, who is responsible for its accuracy and security, and how it will be accessed and stored. Please watch our module on AI and intellectual property rights for a more in-depth discussion on this topic. If the AI system uses open source or third-party models, check their terms carefully. Some may require you to guarantee the origin of your data or allow your data to be used for further model training. This could be a problem if your data includes information you're not authorized to share or is confidential in nature. Consider what ongoing responsibilities your supplier will have, such as updating models, removing incorrect data, and supporting post-deployment data validation. The extent of these obligations will depend on whether you're using a supplier's model or a custom-trained solution. If the AI product is being delivered on-premises, your contract will need to address how updates that would otherwise be automatically available to SaaS customers are to be implemented locally. Make sure you know whether consent is required for your use of AI and that you've carried out proper due diligence, testing and risk assessments. Suppliers should provide information on safety, security, transparency and explainability so you can evaluate risks like algorithmic bias or erroneous outcomes. This will be particularly relevant where you are using AI for decision-making purposes. Don't forget to address compliance with data laws. For an in-depth consideration of this area of compliance, please watch our module on AI and data protection. For critical applications, you may need a kill switch or circuit breaker to halt the AI system if it behaves unpredictably. Where that is the case, you'll need to consider whether the supplier should be obligated in the contract to maintain earlier versions of the system and how the costs of this will be managed. Who is responsible for the risks and liabilities arising from use of the product? This should include consideration of those liabilities arising from regulatory breaches, data misuse, or system failures. Liability caps, disclaimers, and indemnities will be key negotiation points, just as they are in traditional software contracts, but the unique risks of AI require specialist legal input to ensure you are properly protected. Suppliers of AI tools will be reluctant to provide much in the way of guarantees on outputs. However, customers should be wary of accepting commonly included disclaimers where AI is being used as part of a wider service. Contracting for AI services is a nuanced process that requires additional focus and understanding from your contract negotiation team. By addressing the unique challenges, you can safeguard your business and unlock the full potential of AI solutions. Thank you for watching.